For Democrats, the race to define the nominee is going to focus on one issue: abortion.
Do you want the court, including the justices that you will name, to overturn Roe v. Wade, which includes, in fact, states a woman's right to abortion?
Because I am pro-life and I will be appointing pro-life judges, I would think that that will go back to the individual states.
Trump campaigned on a promise to appoint Supreme Court justices who would overturn Roe v. Wade, the landmark 1973 case affirming a woman's constitutional right to end a pregnancy. And as of the start of this month, it didn't seem like his position had changed.
Maybe someday it will be to the states. You never know how that's going to turn out. That's a very complex question, but it could very well end up with states at some point.
Now, Justice Kennedy's retirement gives him an opening to tilt the court in exactly that direction. Kennedy was a crucial vote in pro-choice cases, like an opinion he co-authored in 1992 that affirmed the precedent created by Roe. And more recently, 2016's Whole Woman's Health versus Hellerstedt, which sided with an abortion provider, saying that restrictive regulations on Texas abortion clinics weren't grounded in enough medical fact to justify their effect of limiting access to safe abortions. Laws like that Texas one struck down by Whole Woman's Health aren't uncommon. More than 1,200 state abortion restrictions have been passed since Roe, 1/3 of them in the last 7 years alone. And access varies wildly by state. 27 states mandate pre-abortion counseling followed by 1 to 3 day waiting periods before the procedure. 6 states only have 1 abortion clinic left. And 4 have laws that would immediately ban abortion if Roe is overturned.
An explicit overturning of Roe, a good possibility. But what is almost a certainty is that a court in which Donald Trump has replaced Justice Kennedy with a justice who he promises will vote to overturn Roe will uphold restrictions with no basis in medicine that allow politicians to eliminate abortion access within the borders of their state as surely as if the court had explicitly overturned Roe.
Roe won't be overturned tomorrow, but the process by which it could be eroded is now clear. State legislators continue passing laws restricting reproductive rights, and those laws, when challenged, could end up in front of a conservative Supreme Court that's unlikely to disagree. 3 important abortion cases are currently snaking their way through the federal court system. Mississippi's only abortion clinic, Jackson Women's Health, is challenging a law that the state's vehemently anti-abortion governor signed in March. The law bans abortion at 15 weeks, 9 weeks before the standard established by Roe. Or a challenge, brought again by Whole Woman's Health Clinic, to a Texas law that bans dilation and evacuation, the safest and most common procedure used to terminate a second trimester pregnancy. That'll be argued in November. Or a suit brought by the ACLU and the Center for Reproductive Rights against 4 laws in Arkansas. Those laws cover a wide range of abortion restrictions. They force women to obtain permission from the father, ban D&Es, allow doctors to ask for extensive medical records, and require girls between 14 and 16 to report their abortions to the local police. If any of these cases, or similar ones, make it all the way to the Supreme Court, it's possible that a more conservative majority could do what Trump promised and overturn Roe outright. Or the court could just uphold laws that effectively make it impossible for some women to get abortions.
This is not a fire drill, right? This is not kind of chipping away at the edges. We should make no mistake. Access to abortion is absolutely on the line.